The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. Good afternoon, everyone. Thank you so much for your patience. Just delightful lunch with the winners of the essay contest and their lovely families, and with my colleagues from Maryland. They were basking in the sunshine of a Triple Crown win from Maryland, and a wonderful occasion. So I'll keep my remarks very, very brief. First, I'd like to thank all of you for being here, and my colleagues, especially to convene here to give this great honor to these wonderful young people who, and listening to them at lunch and hearing about what they're doing, I was just amazed. They're like lawyers have schedules that are less filled with events and assignments. Just wonderful. But I want to thank the persons the 5 judges we had, and Andrew Clark is here. Where's Andrew? Thank you. Appreciate your efforts. And I want to let everybody know that when they judge these essays, they do so without knowing the names or the states that they're from. And so I really appreciate that help. But it's a nice time. When I became chief, I said one of the best ways I thought to honor our Constitution was to honor our young people, the future. And I always say that if they lose their enthusiasm and their passion and purpose for our constitutional government and democracy, then we are lost. But I don't think at all they're lost at all. I think we're in good hands, and every time I see our winners, I know, as Franklin said, he knows now it's a rising sun that was on Washington's chair in Philadelphia, a rising sun. So we thank you for that. Now, without further delay, I'm going to call up the persons who will introduce our essay winners and their families. First, Rachel Lee.
Good afternoon. May it please the court, Chief Judge Gregory, circuit judges, honored guests, and all assembled. I have the honor and privilege of introducing this year's 3rd place winner of the annual 4th Circuit Essay Contest, Eli Kupperman. Joining him today are his parents, Annette and Scott Kupperman. Eli is a senior at Long Reach High School in Columbia, Maryland. Eli's days are filled with school musical rehearsals, fulfilling his duties as president of both the Music Honor Society and speech and debate team, as well as volunteering at a shelter for rescue dogs. Eli is passionate about musical theory, computer programming, and cars. His curiosity is never satisfied, and he often spends his free time learning as much as he can about these topics. Without further ado, please welcome Eli Kupperman.
Thank you, Ms. Lee, and thank you to all present this morning. It is an honor to be here amongst such renowned guests and, of course, my family. It is again a privilege this morning to be among my fellow winners. Congratulations. Without further ado, I'm pleased to share with you a work of my own, The Young and Mighty, the Empowerment of an Unheard Voice. As former First Lady and youth advocate Michelle Obama writes in her memoir, Becoming, quote, "If there's one thing I've learned in life, it's the power of using your voice. I tried my best to speak the truth and shed light on the stories of people who are often brushed aside," end quote. The voices of those who are ignored or marginalized often need help to be heard, and America has a long history of passing legislation to assist those whose voice ought to resound as loudly as any other citizen, to speak a little louder, to get their message across. People of color were given the right to vote with the 15th Amendment in 1870, women with the 19th in 1920, and the impoverished and maleducated with both the 24th Amendment and Voting Rights Act in 1964 and 1965, respectively. School students, however, did not achieve this power to use their voice until 1969, with the revolutionary acts of Mary Beth Tinker that led to the decision of the Tinker versus Des Moines case. Interestingly, the amendment with which this earth-shattering decision was justified was simply the first, and raised the simple but puzzling question, what changed? It certainly was not the First Amendment, which was submitted for ratification in 1789 and passed in 1791. Since the legislation remained constant, the only possible source of change in the issue of students' rights are the students themselves. This truth remains apparent today, with the appearances of high school students as political advocates for prominent social issues on national news, newspapers, social media, and talk shows, employing multiple platforms to express their concerns and ideas. The changes in the ability for students to properly and fully use their First Amendment right can be directly attributed to precedents set by revolutionary teenagers, along with the acceptance of student voices as valued contributions to American society. Quote, it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate, end quote. These words are from Justice Abe Fortas in the Tinker versus Des Moines case, which would become famously known as the precedent for students' rights all across the nation. The case began when Mary Beth Tinker, a 13-year-old 8th grader at the time, and 2 older high school students wore black armbands to show support of a truce in the Vietnam War in December of 1965. The students were sent home and suspended because of a refusal to remove the armbands, prompting the parents to sue the school district for violating the students' freedom of speech rights. The Supreme Court sided with Tinker by a 7-2 decision, which was victory for students all across the nation, an unheard of freedom for students in the right to exercise the First Amendment in school. The extent to which the students of America could use their newfound freedom would be tested and expanded over the years. In cases such as Bethel versus Frazier, Hazelwood versus Kohlmeyer, and more recently Morse versus Frederick, students have attempted to expand their freedoms and test the extent to which they can convey a message using the First Amendment. However, in all of these cases, the students have been shut down, as the precedent set in Tinker versus Des Moines is not mutually exclusive from the precedent that the government and its facilities, such as schools, maintain a right to censorship. The idea of censorship can be best explained by the Hazelwood versus Kohlmeyer case of 1988. Quote, a school need not tolerate student speech that is inconsistent with its basic educational mission, even though the government could not censor similar speech outside of the school, end quote. Although this set a clearer precedent addressing the First Amendment interpretation for students within school walls, it also made clear that the government could not censor similar speech outside the school, an idea which would be used to fully empower students to make their voices heard. On February 14, 2018, the unthinkable happened inside of Marjorie Stoneman Douglas High School in Parkland, Florida. A former student armed with an AR-15 style semi-automatic weapon opened fire within the school, killing 17 people and harming many others. After such a tragedy, a voice for good was needed, a voice to lead the people in response to such a horrible event, a voice to prevent such a travesty from ever happening ever again. And this voice appeared, except it was not the voice people expected. It was not a political figure or a celebrity or a sports star. The voice came in the form of the surviving students of the shooting. Names like Emma Gonzalez and Cameron Kasky became household names as millions of people all across the world bore witness to 17 and 18-year-old students leading marches in Washington and speaking on issues which previously were only discussed by adults. An unfolding wave of evolution occurred in front of the eyes of hundreds of millions of Americans. Students, after 40 years, yet again became political revolutionaries and a voice for injustice. Although the scale of the direct political impact of Mary Beth Tinker's black armband pales in comparison to Emma Gonzalez's March for Our Lives, many similarities can be drawn. Both are examples of passionate students determined to make a difference. These young women became household names because of revolutionary actions. And most importantly, they both inspired countless other students to make a difference too. Although the laws have not changed, the inspiration given to the children of America by students like Tinker and Gonzalez have empowered countless voices that were once brushed aside. These similarities are summarized best by Emma Gonzalez herself. Quote, we're going to be the kids you read about in textbooks. Just like Tinker versus Des Moines, we're going to change the law, end quote. Thank you.
Eli is sharp. You know, a lot of times the winners, after they get a speech, they walk off. He knows to stay on the podium. Yeah, there is some. Thank you so much for your wonderful voice. as you mentioned in the book, and you use your voice well, not only your speaking voice, but also you're looking at a wonderful singer of classical music. And I mean, it's just business, and the future, as I said, is in great hands. Eli, thank you so very much for your work, for your scholarship, and for your heart. Thanks so much. Photographer, let's come on this side. And of course, this right here might help you a little along your way. Next, Jocelyn Mannion. Let's get the cats.
May it please the court, Chief Judge Gregory, circuit judges, honored guests, and all assembled. I have the honor and privilege of introducing this year's second place winner of the Fourth Circuit Essay Contest, Lorelei Loraine. Joining Lorelei today are her parents, Wendy and Greg Loraine. As a senior at Mount Hebron High School in Ellicott City, Maryland, Lorelei relies heavily on her alarm clock. In fact, it's not uncommon for her to set 6 alarms to either wake herself up or to remember something important. This obsession, as she calls it, has paid off, not only helping her to jumpstart her busy day, but also to lead her school's dance team to multiple victories as captain. Please join me in welcoming Lorelei Loraine.
I feel very privileged to be here among such esteemed company, and this is the essay that brought me here. Why are alarm clocks not chastised for their disruptiveness? The answer is obvious to anyone who routinely begs for 15 more minutes. Disruption is the point of the alarm clock. This morning intervention is unpleasant, but everyone knows that it is necessary. And thus, millions of people rely on their alarm clocks every morning. Student activists have been the uncelebrated labor of social movements since society began moving. But in recent years, speakers like Emma Gonzalez and Malala Yousafzai have risen to progressive superstardom. At the same time as our culture is beginning to value young activists' role as social alarm clocks, the American court system has been distilling the narrow allowance for free speech in schools. In the years since Tinker and her armband forced the Supreme Court to acknowledge children's political clout, the courts and the American ethos have pulled in opposite directions, moderating each other. Mary Beth Tinker and Christopher Eckert's protest of the Vietnam War was given little attention at first. A preemptive warning from their school, a quiet suspension, and dismissals from the district and circuit courts. The indifference ended when the Supreme Court reversed the decisions of the prior 2 courts and with an opinion on Tinker v. Des Moines that famously proclaimed that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The decision set forth the precedent for many of the issues of student protests that followed. The substantial disruption test, which protects speech that does not distract classmates or impair the school. This adhered to the spirit of the Constitution, rights are universal, but balanced it with pragmatism regarding education. The test has been applied widely, but continues to change even today. The Fifth Circuit Court found that even off-campus speech may be regulated by schools if it materially damages the school environment in Bell v. Itawamba County School Board in 2015. As is characteristic of Supreme Court decisions, there are subtleties in the Tinker decision that have been magnified by subsequent interpretations. The lesser-known invasion of the rights of others criterion for banning student speech was implicated in the 2006 decision in Harper v. Powell Unified School District, which prohibited a student from wearing a shirt destructively condemning homosexuality. Courts found in Karp v. Becken in 1973 and Dodd v. Rambis in 1981 that schools may forestall speech that they predict will be disruptive with reasonable evidence so that they do not have to wait for a rebellion to occur. Since Tinker was decided in 1969, some have criticized courts at all levels for abandoning the protections that the original case provided for free speech in schools, while others argue that the nature of the legal system is to produce clearer guidelines over time. Regardless of opinion, public or scholarly, it is clear that repeated applications have made the precedent set by Tinker more conservative and punitive. Despite this legal trend towards reducing freedom of speech in schools, American society increasingly allows its young people to steer it towards change. Students lead movements about gun laws, the environment, gender and sexuality rights, and nearly every other cause that could be argued for or against. And their activism in school bleeds into the broader social conversation. Walkouts over school shootings inform gun laws. Students on Twitter provoked multinational companies to nix drinking straws. And dress code protests are reflected in empowerment demonstrations like #MeToo. It is undeniable that campus protests were influential before the 21st century. Tinker v. Des Moines was argued in the Supreme Court after all. But modern culture is more accepting and even encouraging of student activism than ever before. The popularity of the internet and teenagers' social media acumen have given young people the new opportunity of instigating change on the global scale, not just the local one. Students who can convince adults that the world's problems affect them too garner respect and attention, and the internet is the perfect vehicle. After the shooting at Parkland High School, students on Twitter drew popular outrage to lax gun legislation. Acting as an alarm that society could not snooze, they condemned the stagnation that happens after school shootings, when promises of reform are never fulfilled. There has been a verifiable rise in student activism in the years since Tinker was argued. And though courts have become more stringent, adults are increasingly accepting teenagers' place in advocacy. The disconnect between the court system and public opinion is purposeful. The increasing conservatism of legal precedents on school speech, for example, is counterbalanced by the rise of young, progressive icons to produce a system based on reason. Youthful alarm clocks signal that change is imminent and kickstart movements to bring it about. Grandfather clocks that clang at regular intervals could never scare people out of sleep, but they are a reliable and trustworthy presence. Since Tinker v. Des Moines was decided, the push and pull of culture and law has developed a social system that balances activism with education. And that balance will likely further improve as people continue to interact with their court system. Thank you.
Wonderful, wonderful, Lorelei. Thank you so much for your wonderful essay and for your work. It's no surprise that you fixed on time because you manage it so well and you do more things. It's amazing. I was just exhausted listening to all the things you and Eli are doing. And let me let you know that she'll put that great calculus of time and management and how people operate in consumers and money, because you're looking at our future chair of the Federal Reserve. That's her. And she's going to be with Dr. Yellen soon. So she's in good company already and inspiring. So thank you so much for the future and what you're going to do for our monetary policy as well. Thank you so much. Congratulations. And likewise, I have a little something for you.
Thank you.
That you can starve in terms of your banking facilities there.
I'll put this into the money supply.
Staging is, I'm theater. Next we'll have Mr. Joseph Coleman.
May it please the court, Chief Judge Gregory, circuit judges, honored guests, and all assembled. I have the honor and privilege of introducing the first place winner of our annual Fourth Circuit Essay Contest, Isabel Sines. Joining Isabel today are her parents, Ashley and Serge, sister Anna, brothers Mark and Daniel. As noted in the program, Isabel is a junior at Edgewood High School in Edgewood, Maryland. Among her interests not included in the program are being a fan of FC Barcelona and also visiting museums. Without further ado, Isabel Sines.
We've heard a lot about young people and their voices today, and I'm very thankful to the Fourth Circuit Court to have me here to share my voice and to have met the wonderful judges of the court, and especially the two that I had lunch with. One's right to free speech is not absolute. Throughout American history, courts have supported restrictions upon time, place, and type of speech to be protected. When student free speech is queried on Google, the results page comes slathered in reports of battles over religious iconography, student journalism, social media posts, and online harassment. In short, controversy. Yet, these are issues that Mary Beth Tinker was hardly thinking about when she wore a black armband to school to protest the Vietnam War, and issues that her court case never touched. Tinker v. Des Moines is the textbook student rights victory. It established that students do not, quote, shed their constitutional rights at the schoolhouse gate, unquote. And it created the Tinker Standard, a test which can be administered to student speech cases to ascertain whether their speech is protected under the First Amendment. As with many cases turned precedents, Tinker is not a one-size-fits-all solution. It has been challenged over the years in the increasingly complicated realm of students' voices and the ways that they are heard. In that sense, the Tinker decision is very much alive and evolving, moving backwards and forwards in the scope of its protections, piloting new cultural obstacles, and maneuvering through new territory as time marches forward. Subsequent cases, Bethel v. Frazier and Hazelwood v. Kuhlmeyer, are viewed as steps backwards from Tinker, allowing schools broader jurisdiction over what students can say. The first held that administrators could prevent students from giving vulgar or lewd speeches that were, quote, inconsistent with the fundamental values of public school education, unquote. The second allowed school officials more leeway in censoring school-sponsored newspapers. In both cases, the Tinker ruling did not force schools to protect certain kinds of speech. Following Hazelwood came tragedies like the Parkland and Columbine shootings, after which schools were presented with another complicated layer of student speech, protecting their students from violence from peers. Following the cultural fallout of the Columbine shooting in 1999, the school and others expanded zero-tolerance policies pertaining to drugs and weapons to include, quote, controversial student expression in poetry, songs, and art, especially if such expression appears to be tied in any way to potential acts of violence. In the law, those are dangerous words. They have incredible potential for abuse in their ambiguity. The heavy peals of Columbine's warning bells can be heard in several cases fought in its wake. In Levine v. Blaine School District, a student argued that he was wrongfully expelled after writing a poem examining the mindset of a hypothetical school shooter. Applying the Tinker Standard, the court ruled in favor of administrators. The case had to be deliberated considering the current environment. Quote, taken together and given the backdrop of actual school shootings, these circumstances were sufficient to have led school authorities to reasonably forecast substantial disruption. Similar in tone was Emmett v. Kent School District No. 415, in which a student was suspended after a website was found with tongue-in-cheek obituaries of students and a poll which allowed visitors to vote on who would die next, or whose would be the next mock obituary. Noting the minor resemblances to the website Eric Harris had maintained prior to his killing spree, a reporter called the website a hit list, and the student was promptly suspended for intimidation, harassment, and disruption to the educational process. The court ruled in favor of the student despite the alarmist characterization by the media, as there was not enough evidence to prove the student was intending to do harm, and the website did not meet the Tinker Standard. Uniquely modern dangers like cyberbullying forced Tinker into a corner. If speech is made outside the proverbial schoolhouse gate, can schools suppress it? A new area of law developing at breakneck pace, social media prosecutions are only just beginning, and Tinker's interpretation is being reworked to fit this newest set of criteria. In 2015, Reed Sagehorn sued his school for suspending him over a tweet made about a teacher outside of school hours and grounds. A Minnesota judge in Sagehorn v. Independent School District No. 728 ruled that school officials could not suspend students over such posts unless they are, quote, true threats or are reasonably calculated to reach the school environment and are so egregious as to pose a serious safety risk or other substantial disruption, unquote. It set an incredibly high bar for schools to prove that posts cause disruptions in line with the Tinker standard. The case also established that schools can only use Fraser's allowance to define vulgar speech as they see fit when it is made on campus, regardless of whether or not it is digital. The verdict at once expanded and limited Tinker's initial protections. Conversely, there are cases like Bell v. Itawamba County School Board, which arose the same year. In this case, the Fifth Circuit Court found it acceptable for administrators to suspend a student for posting a rap song to YouTube that harassed and intimidated teachers. The majority opinion was that teachers, quote, reasonably could find Bell's rap recording, threatened, harassed, and intimidated them, and a substantial disruption reasonably could have been forecast, unquote. In other words, it passed the Tinker test. Echoing Levine, the judges cited increased school violence as a factor in their verdict. Democracy and our society are constantly in a period of change. Its institutions consistently evolve to meet new challenges and solve modern problems. Free speech is a work in progress. Our vast tome of laws is a work in progress. Tinker has undergone quite the makeover in response to its innovations and changes in our culture and thinking, but its heart has remained true. A landmark Supreme Court case, its precedent that students will never be required to shed their constitutional rights at the schoolhouse gate, is the undercurrent which has carried all subsequent lawsuits for and against students over their speech, from symbolic armbands to Twitter posts to unfurled banners reading bong hits for Jesus, and a memorial to our founding principles of freedom and liberty. Thank you.
Thank you so much, Isabel. I don't have as much recon on Isabel. You have to talk to Judge Harris and Judge Niemeyer. They were at her table. But your essay says it all. You know, I'm reminded, step up a little bit. There you go, so they can see you. I'm reminded in Meacham's book, The Soul of America, he says, much of the vibrancy of the American story has been the effort of the powerless to make the powerful take note. And you certainly have done that in terms of a Tinker, in terms of the essence, and those students and those freedoms to make the powerful take note of the powerless. And also, too, don't worry about Oscars. I want an unfair advantage. Just send yours straight to me, okay, for clerkship in the future. Awesome job. Thank you so much. Beautiful essay. Wonderful. And for you, something there, and your certificate. Come over here and take a picture. Okay?
Yes.
Isabel's family, please stand up. Let's give them a hand. Lorelei. Eli. Thank you so much, and I enjoyed meeting the families, just wonderful conversations. Thank you so much. We have a reception downstairs. I know you've been very patient, but please come down, because one of my favorite parts is that we ensconce them in the history of the Fourth Circuit by being in our library on this wonderful perpetual plaque. And I tell them when their grandchildren or other relatives for years to come will come here and say, Grandmom, Granddad, they were winners in the Fourth Circuit essay contest. And that's so meaningful. And there's some nice cake and a beautiful cake that celebrates our Constitution. With that, thank you so much. We appreciate it. Thank you.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.